Start. The Honorable Supreme Court, in the case of State of Karnataka (Supra), again reiterated that in the exercise of judicial review, the court does not act as an appellate forum over the findings of the disciplinary authority. Full stop. The court does not reappreciate the evidence on the basis of which the finding of misconduct has been arrived at in the course of a disciplinary inquiry. Full stop. The court, in the exercise of judicial review, must restrict its review to determine whether the rules of natural justice have been complied with. The finding of misconduct is based on some evidence. The statutory rules governing the conduct of the disciplinary inquiry have been observed, and the findings of the disciplinary authority suffer from perversity, and the penalty is disproportionate to the proven misconduct. Reappreciation of evidence and allowing the parties to lead the evidence are two distinct issues. Full stop. The judgment the appellate relied upon regarding the powers of the tribunal to allow the parties to lead the evidence is not a matter of judicial review. Full stop. It is an opportunity for the parties to supplant the material to prove and disprove the charges against the delinquent. Full stop. Such action cannot be equivalent of the tribunal under judicial review. Full stop. The law is already well settled, and the direct rules of evidence and proof do not apply to departmental inquiries. Full stop. The sufficiency of evidence is also not within the realm of judicial review. Full stop. The standard of proof required for a criminal trial is not allowed in departmental inquiries. Full stop. The findings of the learned tribunal are clearly in the form of reappreciation of the evidence. Full stop. So far, the charges that the tribunal has declined to accept have been proved. Full stop. However, he believes the two charges are consistent absence and incorrect valuation of the answer sheets papers of the students. The respondents have raised the objection that the tribunal has no power to reduce the punishment proposed by the inquiry committee. Full stop. Section 11, subsection 2 of the MEPS Act, is crystal clear, empowering the tribunal to modify the penalty if it is disproportionate in order to prove misconduct. Full stop. Therefore, it does not require more discussion. Learned counsel for the respondents has vehemently argued that the charges against the appellate of incorrect assessment of the mark sheets and giving lesser marks to the students is misconduct as defined under Rule 28 (5) of Rules 1981. Full stop. He has vehemently argued that the learned tribunal has incorrectly observed that the case of Shikshan Prasarak Mandal all MR 773 does not apply when the ratio laid down in the said case was squarely applicable to the case at hand. Full stop. He would submit that once the tribunal accepted that such a serious charge had been proved against him, he ought not to have interfered with the punishment specified by the committee. Sub-rule (5) of Rule 28 defines the term conduct. Full stop. It concludes the valuation of the code of conduct. Full stop. Rule 22 of the said rules provides for the code of conduct and the duties of the teachers and non-teaching staff. Full stop. Subclause (D) of sub-rule (2) of Rule 22 speaks of impartiality of the teacher in assessment of the students, and he teacher shall not deliberately overmark or undermark or victimize students on any ground. Full stop. The charges against the appellant giving lesser marks have been proved. Full stop. The appellant has no evidence against such serious charges in rebuttal. Full stop. Violating the code of conduct is misconduct for which the severe penalty of termination from services may be imposed. Full stop. The Bombay High Court, in the case of Shikshan Prasarak Mandal in bracket Supra, dealt with identical case in which the teacher was held guilty of malpractices while undertaking the work of violation of the answer papers of the higher secondary examination. Full stop. The court has discussed Rule 28 in bracket 3 and 22 in bracket 2 of the rules and held that the order of dismissal of the teacher from the services was proper. Full stop. It has also been held that the teacher who does not himself honor his own position and sanctity of such important examination and on the contrary violates it cannot claim any right to be continued as a teacher.